Now, earlier on our show, our law panel covered the history of the mortgage crisis and the effect it's had on homeowners all across the country. In this segment, we'll be discussing the specific abuses by lenders that our panel has uncovered that can affect your rights as a homeowner. Let me ask you, what are the primary problems that all of you have found with practices of mortgage lenders that can negatively affect homeowners?
Well, let me tell you what the lender's approach is when they approach these cases. Lender's approach is, despite anything that may have happened with our recorded documents, as long as we fix it before we foreclose on you, judge, ignore everything that happened. So in my experience, I see documents that are out of order. I see missing documents. I see trustees that are taking acts to foreclose that haven't been substituted in. I see beneficiaries that are recording notices of default or notices of trustee sale that haven't actually been assigned the deed of trust. And so I go in and I argue that these documents that should have been recorded that aren't recorded, they need to record these documents. Because they haven't, they don't have a right to foreclose. Sometimes, believe it or not, the party in court that's attempting to foreclose on our clients doesn't actually hold the note or have the right to foreclose on the homeowner.
About 2 months ago, just about every major financial agency of the U.S. government got together. The Treasury Department, the FDIC, the Office of Thrift Supervision, and they forced the leading banks in the United States to sign consent decrees. And together with the consent decrees, there were findings. And those findings included lack of signatures on documents necessary for the chain of title. The findings included robo-signing. The findings included weak control systems in which affidavits may have been signed under oath that may not have been true. The findings were that the use of an entity called MERS, which is a entity formed by the banking industry to try to take the assignment of deeds outside of the normal county registration system, may have had defects. And in these consent decrees signed with the federal government said that it was requiring the banks to supply considerable additional information because it might force the banks in some cases to give money back to homeowners where there had already been foreclosures. So the federal government has recognized, and the banks through these consent decrees have recognized, that there have been massive defects in the system from the initial recordation of the loan to the purported assignment of interests in those loans as part of the collateralized mortgage sales, or the purported assignment of servicing rights in those loans that in many instances are not backed up by the proper documentation. And the laws in most states and federal laws in most instances require that in order to foreclose on a loan, the bank or the servicing company foreclosing has to prove that it actually owns the loan or has a valid right to foreclose on the loan. And it's usually supposed to show that by showing contemporaneously recorded documents. Now, there are exceptions, and that's why I use the word generally, but the problem is severe and pervasive enough that the federal government has gotten into this act in a very major way. This is a very large problem, a recognized problem, but it's only part of the problem.
I was just going to add, because Kennan's practice in this area focuses mainly on the mass tort actions. My practice focuses more on the unlawful detainer defense and individual lawsuit type situation. And so in the individual lawsuit, the other approach that we take is some of these people, when they got into financial hardship, they went to the lender to try to seek relief. They were what I call led down the rosy path, and that is they were led to believe by the lender that they would get a permanent modification of their loan, while in some instances the investor on the loan, the person calling the shots as to whether the borrower gets a modification, they have a contract with the servicer that says they cannot modify the loan, and the borrower's never told this. So they're led to believe if they make trial payment plans on a trial modification, that at the end of the day, at the end of the trial modification, they'll receive a permanent modification. Well, a lot of these people faithfully paid on their trial plan. They were put into this circus, I'll call it, of mod review, providing financial statements. The lender rep loses documents. They say they never received documents. So it's sometimes months upon months upon months of going around in circles and trying to get a modification. and making these trial modification payments, and then they get a denial letter. And we find out at the end of the day, they never could have got modified to begin with.